Linda Tucker. Anyone here for that case?
Yes, Your Honor.
All right, sir, come on down.
Good morning.
You ready to proceed? I just want to tell you, we've read all of your files, read the record, read the transcript, so.
Yes, Your Honor.
You're prepared, so you'll have 20 minutes, but you also have the right to reserve time for rebuttal. We'll give you a maximum of 5 minutes of rebuttal if you would like to respond to her argument.
Yes, Your Honor.
You can take the full 20 minutes, or you can just take 15 and then the 5.
I think I'm going to take the 15 and the 5. Thank you.
Sir.
Yes, Your Honor.
You may proceed.
Yes, sir. And for clarity, I'm the plaintiff also in the lower court tribunal, and I've been self-represented throughout, and I do want to preserve my 5 minutes.
Yes, sir.
And again, may it please the court, I'm the appellant Shagret Dawson. This is an appeal of the lower tribunal's final order issued on July 12, 2022, and ultimately dismissing with prejudice appellant's complaint for damages against defendants Chandra and Linda Tucker for injuries suffered as a result of Chandra Tucker intentionally, and I say it by virtue of her own admission and deposition, committing a rolling stop into the back of a vehicle that she wasn't distracted, clearly saw, and hit nonetheless. Furthermore, every issue raised in my brief is supported by the record, to include the transcripts I provided for the court as well, including the potential criminal conduct of the defendant's counsel and their so-called expert witness, who, as you've read the transcript, we found out that he actually saw me for the compulsory medical examination without disclosing to me that he was a VA doctor, then subsequently saw me at the VA, and it was kind of strange. It was a Saturday. That's how I discovered that he's actually a VA doctor. So we may have an issue involving Title 18 United States Code, Section 208. But before dismissing my 2018 complaint, the lower tribunal managed to deviate kind of without discretion from many issues of well-established law, to include allowing defendant's attorney to instruct the client, who's my witness at deposition, to not answer questions in the deposition. He didn't halt the deposition and then ask to have it continued. He just said, do not answer that question, and that's inside the transcripts that I provided for the court as well. On several occasions, the trial court muted my mic during the Zoom hearings without any basis or warning. And in one of those hearings, the trial court judge said to me, and I'm at the time, I'm 50 some odd years old, I'm 55 today, "You're not going to argue with Mr. Roe in my courtroom, do you understand?" And I think we can all see why that would be pretty disrespectful, to tell me I can't argue my case before an attorney who had already, in many instances, violated the rules of professional conduct. And I'm not an attorney again, but I read quite well. The trial court violated due process of law, and essentially took a case that I filed in 2018, we're still here in 2023, almost 2024, by granting the defendant's counsel's intentionally misleading motion filed on behalf of a party that he didn't represent. Despite the facts presented that I presented to the court to demonstrate that the firm filed a frivolous motion. Some would call it a sham pleading. The trial court judge then ordered me to sign a letter releasing parties that had not made an appearance into the record pursuant to the rules, did not sign a certificate of authority, and also it included language that was not included in the stipulation, and it undermined, because I don't want to get into the privilege issue, but it undermined what we talked about in the mediation. And none of those parties were present at the mediation at all. And none of them, again, as you look into your record, and I actually provided a copy of the docket as well, there's only certificates of attendance and authority for Chandra and Denise Tucker. Why the trial court wanted to force me. I did sign that release under duress because I didn't want to catch a contempt charge because of my, I guess, well-earned reputation. But I went ahead and signed it under duress, and if they show it to you, I did sign the release under duress, and I had a witness. The trial court continuously operated on behalf of the defendant's counsel, including denying my motion for leave to amend for punitive damages based upon her testimony in the deposition when she said, I wasn't distracted, I had control of the vehicle didn't have any mechanical issues. She saw me and she did a rolling stop. She said it several times. So now we don't have an accident. You hit me on purpose. And I gave her, and also asked her to disqualify herself on multiple occasions, which I'm sure is in the record. She refused. However, when I filed a subsequent action for what I would probably think now would be more of a, based on the facts, constructive fraud to bring me to the second mediation, because this was the second mediation, for the purpose of the defendant's counsel trying to obfuscate from what he and his expert witness, and also apparently the Department of Veterans Affairs had done the whole time. Because I also found out later on that the VA settled the claim for an amount that, when added to my amount, would give the VA more than 1/3 of the settlement. The VA has a general rule that they take 1/3. They took more than 1/3. Now, what's odd to me also is they settled this issue and no one spoke to me. But oddly, State Farm's attorneys had access to the VA counsel, I guess high-level VA counsel, which is kind of strange. And if we're not for myself, I stand here on behalf of every veteran who we did what we were asked to do, and many like myself who were honorably discharged, and some gave a lot more than I gave because I'm still standing here. And all we ask you to do is what the law requires you to do. So with that being said, I would ask this court to issue an order to just essentially start everything all over again from the beginning, based upon issues of relevant law. And if there's any other questions, I'm more than willing to answer them.
All right, sir. I don't think we have any. You have 5 minutes to counsel. Thank you.
Yeah. Thank you, John.
Yes, sir. Oh, by the way, that mic doesn't move. It's kind of blocking your face. But
Oh, I apologize.
It's flexible.
Did you all hear me well?
Oh, yeah.
Okay, thank you.
Fine.
Yes, sir.
I just didn't know if you could see us.
Yes, John.
Yes, ma'am.
May it please the court, good afternoon. My name is Deanne McLemore, and I represent the Appellees Chandra Tucker and Linda Tucker in this action. We ask that the court affirm the final order of dismissal in this matter. Mr. Doss's 5 challenges to the trial court's dismissal really boil down to 2 main issues. One, he believes his due process rights were violated throughout this underlying litigation because of various instances that he alleges of judicial bias and other injustices, as well as he believes that the subsequent release, this letter of release as he calls it, was a counteroffer to the mediation settlement agreement that was made between the parties, and therefore no enforceable settlement exists. Along with some waiver and preservation issues, the record and the law just do not support his arguments for reversal. First, it's made abundantly clear by the record, Mr. Doss was afforded every proper measure of judicial process in this action. Throughout the entire course of this litigation, Judge Peacock treated him with fairness and respect. He never was precluded from filing any documents, making any motions, responses, filing any evidence. He was given the opportunity to depose everybody he sought to depose, my clients and Dr. Shim, although he chose not to depose Dr. Shim after being given the opportunity to do so. At every single hearing, he was given full and fair opportunity to make his arguments and rebuttal to my clients' arguments. There were limited instances where Judge Peacock did have to control her courtroom, but in every instance, she acted fairly and reasonably in controlling her courtroom. All parties here were afforded due process. All her actions and rulings were reasonable, legally and factually supported, and well within her discretion. The second is that Mr. Doss did settle this case at mediation. He willingly and voluntarily entered into a mediation settlement agreement, and he doesn't contest that here. That agreement expressly incorporated release terms, including a listing of the exact parties and persons that he's now taking issue with, That agreement also had a term for a separately executed general release, that second subsequent release.
But is it your position that the letter of release is effectively superfluous given the language of the stipulation?
The letter of release or subsequent relief is not superfluous. It is just a term, an enforceable term of the mediation settlement agreement. It's the mediation settlement agreement that is actually the settlement contract here. It lists out different release terms or enforceable terms, including my clients would pay the $30,000. They would satisfy, State Farm would satisfy Mr. Doss's VA lien against him, as well as a separately executable general release and indemnification agreement. Both parties, all parties, agree to be bound by those terms. Mr. Doss voluntarily and willingly signed that agreement. That is the settlement contract.
So if he was muted during these hearings, I can read where it was turned back on. Was he allowed to complete his arguments?
Yes, both instances. There were only 2 instances in the entire record where the judge was forced to mute Mr. Doss because of his interruptions during my clients, the Appellee's arguments. As soon as my clients were done making their arguments, the judge unmuted him and provided him the opportunity to make full rebuttal argument. At no point did he object to that, or did he ask for more time. During those entire proceedings, he made his full affirmative argument as well as his full rebuttal argument.
So when the court said that she was not going to let him argue with opposing counsel, she literally meant it wasn't an argument between the 2 of them. She wasn't saying you can't make your arguments before the court. Is that what you're saying?
Yes, Your Honor. What it was at the end of that hearing. I can give you a record site. It is 707. It's at the end of that one hearing, and he had a full and fair opportunity to make his full argument. And it was during the end part where they were talking about the ruling that Mr. Doss actually was arguing with my client's trial counsel directly and not with the court, which, as we know, is improper. It would be the same if I turned to Mr. Doss right now and started directly making my argument to him, which I would be most likely reprimanded for doing so. So the argument is with the court, and that's all she was saying. There was nothing by that, and then everybody moved on.
But it seems thereafter in the same hearing, Mr. Doss brought up the rule of completeness, 90.108, about getting records from Dr. Shim, that Judge Peacock informed him about a Bosher hearing, meaning that's a discovery request that you can make to a physician for his or her financial records indicating whether he or she had been retained by your office or the carrier and things like that. So, was that ever done after that?
No, Your Honor, not that from my review of the record, from what I can remember, I do not believe that was done. After this hearing, as you noted, that Judge Peacock at the end of the hearing advised Mr. Doss on what Bosher discovery is to get the financial discovery that he is seeking, as well as gave him another opportunity and advised him to go ahead and get Dr. Shim's depo if that is what he wanted to do to help his case. She just placed reasonable conditions on that deposition, which he does not challenge here today in this appeal. And he did not go forward and take that deposition. And from my understanding, the record didn't do that discovery. But again, this case did settle in mediation thereafter.
But for State Farm settling or satisfying the lien, would he be responsible for it?
It is my understanding that he would technically be responsible for that lien. So State Farm
offered to negotiate?
So State Farm offered and negotiated with the VA to satisfy his lien in full that would be from his injuries from this accident. So along with the settlement check that my clients gave over, which he has the money, the check has been negotiated, he has the settlement funds, State Farm has indeed satisfied his VA lien as it relates to the injuries from this accident. So at the end of the day, my clients, contractual obligations and duties under this settlement agreement have been fulfilled, and Judge Peacock didn't err in compelling Mr. Doss to then satisfy his obligations and duties under the agreement, which were to execute the release, or the order would deem it executed within so many days, as well as dismissing this action with prejudice. Unless this court has any other questions, I would be happy to answer. I will yield the rest of my time. We ask that this court affirm the dismissal of this action. Thank you.
Mr. Doss, you have 5 minutes, sir.
Thank you, Your Honor. Okay, I find it interesting that Appellee's attorney is here making statements for something that she didn't witness. And the record, she does not dispute that the stipulation agreement included parties that were not represented by counsel. I can go to Rule 1.720, 1.730. Furthermore, in the Crawford case, it said mediation could only achieve the goals helping the parties in dispute. I didn't have an issue with Dr. Shim. Dr. Shim, State Farm, Austin Roe Basquil are not named as parties to my complaint. The complaint was for Chandra and Linda Tucker. Furthermore, we can talk about the mirror image rule. And I don't want to, I think it would make it because of the mirror image rule. The release became superfluous because they could have released it and the funds on the date of the mediation. They came back. I was in Georgia for my aunt's funeral. When we come back, days later, they come up with a release that included language that was not, and again, I don't want to get outside of the privilege rule of the mediation. I had no idea what they were talking about. The other parties could only resolve an issue, and the only thing we could resolve is the issue about Chandra Tucker rear-ending me on purpose on January 16, 2017. Every other instance and issue would have occurred after that date. I didn't know who Dr. Shim was prior to that, despite the fact that he's a VA doctor. I didn't know anything about Austin Roe and Basquil. I didn't even know who Chandra and Linda Tucker was. In fact, I had to go through a bunch of hoops just to find Miss Tucker. Nevertheless, let's get to the issues of law. Beyond the mirror image rule and the fact that the rules are clear, if a person doesn't come themselves, they have to have representation. But because every entity, with the exception of potentially Dr. Shim, is a business, Florida law would require them to have an attorney represent them. There's no, and I don't recall unless I missed it, Appellee said that Mr. Roe or Austin Roe and Basquil made appearances on behalf of Dr. Shim, not that there wouldn't be a conflict, the VA and every other party that was named in the release. And if you look at the release includes people other than the Tuckers. And the only thing we could have discussed was the Tuckers. And again, we talk about full and fair. What's not full and fair is to Dr. Shim's deposition, which he did not appear at, but he didn't appear based upon our information because of instruction by people who didn't represent him. His counsel didn't file an objection. The appellee's lower tribunal counsel filed the objection. And here's a subpoena duce testament in here. I want to read from his motion for protective order. He states clearly that Mr. Doss did not properly serve Dr. Shim. He merely mailed it to him. But here's a copy of the affidavit of service from my process server that stated he was served in his office. Plus, we don't know really, is Dr. Shim solely the attorney for State Farm? Or is he the attorney for the United States government because he saw me in two different capacities, yet never disclosed his conflict? And I'm going to say this. It's not the issue that he has a practice outside. 'Cause I went to his practice outside of the VA. I don't have an issue with that. I appreciate the United States government and the taxpayers providing us with help from people who are experts in their fields. That's not the issue. Do what you do. But what you cannot do, and law prohibits it, is to have a financial conflict of interest. That's clearly defined. That's a crime, actually. Title 18 of the United States Federal Code is a criminal action. And the fact that the attorneys for the appellees would come in here and essentially just verify that the attorneys did all this, I think should be reprehensible to anybody listening to this, but particularly as veterans. Because if nothing else, they don't only take care of us for our physical ailments, they also have access to our mental health records. I'm not just speaking for me. We also may have a HIPAA issue here. Because when I asked Dr. Shim, what did you tell him about me? He said, I can't tell you, which sounds kind of crazy, but I'm sitting looking at you inside the VA. Not to mention, he never mentioned at all, and you can go and pull their reports. In the original CME, he doesn't mention to me that he worked for the VA. And in my VA appearance, he doesn't mention in the VA records that he saw me personally. That's not an accident. And again, I speak on behalf of all veterans, I believe, who would like to know if any of our doctors are conflict. Because it goes to the basis of our care. But with that being said, I'll stand on the mirror image rule, the Florida rules of procedure, well-established law. And even when it comes to a sham pleading, and if the court would give me a couple seconds, hopefully I didn't run out of it. Unrepresented parties, the court has previously acknowledged that an attorney is not authorized to represent any person without the consent of that person or someone with the authority to represent that person. It didn't happen for anybody other than the Tuckers. In a sham pleading, it described a sham pleading as a mere pretense set up in bad faith without color of fact, a plain fiction, and that's West Palm Commission versus Abrams, and it's 633 SO 2D 568 to 70. And
You're at your 5 minutes.
okay, I appreciate
A
that.
few seconds to wrap up.
Okay, and the other part about the judge rewriting the settlement. Settlement, under the guise of enforcing the settlement agreement, the trial court impermissibly rewrote the settlement agreement. If the mirror image rules essentially says if there's 100 words in this stipulation, there shouldn't be 300 in the release. Period. I appreciate you all's time. Thank you for the additional time, and shout out to Thomas Jefferson High School.
We thank you for your service to the country, sir.
Yes, sir, the honor was mine.
We'll have a good holiday season. Thank you very much. Safe travels.
All rise.